All right.
Thank you, Your Honor. May it please the court. I am David Sharp on behalf of Ray Yields and Karen Behon. I thank you for the introduction that the court has reviewed the briefs and the facts. This is a fact-intensive case. It's a mortgage foreclosure case.
And before we proceed, will you be reserving any time for rebuttal, sir?
5 minutes, please.
5 minutes? All right, sir.
Thank you. One of the issues is, I think, a jurisdictional issue of whether the trial court had jurisdiction to enter orders in 2010 and 2011, which essentially vacated a sale and, in connection therewith, a final judgment which was entered in May of 2009. Our position is the Sterling Factors case from the Second District Court states very clearly that Section 702.07 Florida statutes permits set-aside decrees of foreclosure after a sale. Also, Rule 1.540B.
And before you get to that, let me see if I could follow the sequence, because as you indicated, it is fact-intensive.
Sure. And
correct me if I'm wrong, that in this case, we had a final judgment that was entered in May 2009, correct?
Correct.
All right. Then after that, a certificate of title was then issued on December 1, 2009, correct?
Correct.
All right. Then there was a motion for writ of possession. The plaintiff basically served a writ of possession. This would be on March 2010.
Right.
And it was at that time that there was an objection to that, correct?
Correct.
But before that, and this is my question to you, when the final judgment was entered and when the certificate of title, was there any appeal from that final judgment or certificate of title?
There was no formal appeal from that judgment. However, before the certificate of title issued, there was a motion to vacate the sale, which serves as an objection to a sale. The clerk should not have issued the certificate of title because an objection had been filed 5 days after the sale, and the 10-day period had not yet run. So there was an objection timely filed to the sale. One thing I would point out to the court that is special in this case, and I think puts it in a different category than many cases, is that this is a case filed by the law offices of David J. Stern, and January 7th, 2014, the Florida Supreme Court approved
And we recognize all
okay.
that. We just want to be able to deal with the facts of this case. As you can tell, there's thousands of cases that we have seen come through.
Sure.
And even regardless of maybe the impropriety of a certain lawyer's action, we still have to look at the merits of the case. You
Fair
agree
enough.
with that, sir?
Of course.
All right. So let's go through.
In that connection, is there any evidence specific to this case that there was any fraud or misconduct in connection with the assignment that serves as the basis for the bank's claim of standing here? Because I don't see it in the brief.
Absolutely, Your Honor. This assignment of mortgage was purportedly signed by Cheryl Samons. She was the person that ran the David J. Stern's office, and this is all found in the report of the referee, which is cited in the appellate briefs. Now,
right, and I get that the report of the referee makes reference to what this person may have done in other foreclosure proceedings, and I'm asking a different question. I mean, there was an opportunity to depose the bank's witnesses. Was there any evidence of fraud in this specific proceeding?
I guess I would point out with the depositions that were taken in Des Moines, Iowa, the Wells Fargo persons that signed subsequent affidavits, both of the deponents had no knowledge about the assignment of mortgage of Cheryl Samons that she had signed. So Cheryl Samons was never deposed. It was the deposition of the two corporate representatives of the affidavits had been filed in 2011 and 12, I believe it was. But I would submit that the court can take judicial notice of the findings of fact of the report of the referee. But in addition to that, in the David J. Stern case, in addition to that, I would point out the lack of knowledge of the affiants who then filed subsequent affidavits as required by the court orders to prove up their standing. I would point out as well, Also cited in the motion is another affidavit of Cheryl Samons that was signed and was backdated beyond 4 years. And that was also cited too in the motion, and that's the case of U.S. Bank v. Penzin, which was cited from the Circuit Court of the 13th Judicial Circuit. So while there was no specific deposition of Cheryl Samons taken in this particular case, I would point out the arguments just made.
Well, from my review of the record, the summary judgment, final judgment of foreclosure was never vacated. The sale was vacated, but
Right.
the final judgment was never vacated. So why are we here arguing the merits of the final judgment when there was no motion for reconsideration and there's no 1.50 motion for relief that specifically alleges fraud? I understand the circumstances about counsel being ill, but the rules still apply.
Sure.
And this is not, it does not appear to be a sufficient motion alleging any fraud on the basis of 1.540.
I think by looking at Judge Silver's order of January 2011, it does indicate in the title that it's an order to vacate the final judgment. I believe on the court on its own initiative can also rely on 1.540B, and some of these facts about the circumstances of the David J. Stern law firm were coming to light, which were not known to the court when they entered the final judgment. As Your Honor is aware, the final judgment was predicated on an affidavit to support the motion by an employee of the law office rather than a bank employee. There was no original note filed. There was no reestablishment of a lost note, and questionable assignment as well. I think all of these factors factored into the court's decisions of Judge Padgett and Judge Silver when they required plaintiffs to prove up its standing. And of course, the motion filed by the defendants were essentially pro se with their attorney sick. And I think the court can look to the contents of the motion, and even though it didn't cite perhaps 1.540B, the contents of the motion prevail over the title of the motion.
As I understand what happened is, we don't know, because we don't have a transcript, or we don't know what proceedings, what the court prior to that initial judgment heard or did not hear. We don't have that. You agree with that?
Of course, yes.
And as I review the file, and it appears to me then you have a subsequent judge coming on board. There's an argument made by the homeowner saying there's an issue of standing with the court in abundance of caution, kind of froze everything. Let's deal with that issue. You agree with that assessment?
I do.
So I know you made a comment here, well, there's been no, you went through in detail as to what was not provided at the initial thing, but we really don't know that for a fact, do we?
No, I'm relying on the record before us.
Right.
Yeah.
All right.
Yeah.
The plaintiffs did file a response to the bank's summary judgment motion raising the asserted failure of proof on standing, right?
Yes, it was one of the affirmative defenses.
So is it a fair assessment of this record that that matter was litigated and resolved by the initial uniform judgment of foreclosure?
I think on the surface, yes. However, Judge Silver's subsequent order, I think, took a closer look at what had gone on and what had happened. And by that time in 2010, David J. Stern's office had shut down and things became known of what was going on there. And his order was entered in January of 2011. So it is my understanding that the court, in its first instance, acted with haste and maybe not the diligence it might have, and then it worked to correct its error later, and I believe it had jurisdiction to do so under the Sterling Factors case and Rule 1.540B. One of the other issues is the hearing of December 19th, 2013. We understood it was going to be an evidentiary hearing. We could present objections to plaintiff's motion to reaffirm a sale. A look at that transcript is the part where that motion is heard is essentially the judge's ruling with no argument. And it's pages 10 through 12 of the transcript. It's, the court had already decided how it was going to rule and did not entertain an option for argument or presentation of any evidence at that hearing. And it's our position that was a denial of due process. We didn't get to put on our objections to the depositions of what occurred in Des Moines, Iowa, of the two Wells Fargo corporate representatives, or affiants, I'm sorry. And then we also didn't get to argue anything about David J. Stern's law office. More information had become known by that time. The report of the referee had come out a month and a half prior to the hearing. So these are things that the court was to be made aware of at the hearing, among other considerations, but the transcript is clear that the court wasn't going to entertain any argument at the hearing. We were set for a 1-hour hearing on December 19th. The hearing began 26 minutes late, and the court just went ahead and ruled without entertaining argument, and we feel that that was a denial of procedural due process, as argued in our briefs as well. I guess I'll retain the rest of the time for rebuttal.
Very good. Thank you, sir.
Mm-hmm.
Good morning, Your Honors. May it please the Court, Todd Armbruster appearing on the behalf of the Appellate Bank of America. Your Honors, there's no question that this is a fairly lengthy and convoluted fact pattern in this case. However, the issues in this appeal are actually fairly simple and straightforward. The only orders that are properly before this court were entered in January of 2014. There was 3 of them. There was an order that granted our motion to reset a foreclosure sale. There was an order that granted our motion for additional attorney's fees and costs. And there was an order that granted our motion for a protective order regarding discovery and denied a renewed motion for mediation. Those are the only issues that are properly before this court for review. As this panel has properly noted, this lawsuit is predicated on a judgment that was entered in May of 2009. It was never vacated. To the contrary, the trial court entered an order on July 31st, 2013, confirming the judgment was in full force and effect, had never been set aside. And so in this appeal, the appellants have the burden of demonstrating that there was some form of an abuse of discretion when the trial court entered those 3 orders in January of 2014.
The court still, I mean, even within that period of time, the court nonetheless gave them what they wanted, stopped, allowed the deposition to take place, managed to get your client to submit any type of evidence to show standing again. So it wasn't just, I guess my question to you, your opponent makes an argument that there was a lack of due process. Was there a lack of due process in this case?
Your Honor, candidly, I think that there was more due process given than would ordinarily be given in this type of circumstance. Again, there was a final judgment entered in May of 2009. At that point, realistically, the trial court lost any further jurisdiction over the matter once the time for filing a motion for rehearing had expired. There was never an appeal. So that judgment becomes final. At that point, the only thing that the trial court had the jurisdiction to do was enforce that final judgment. Rather than immediately confirm the certificate of title, the judge took a step back, allowed discovery to be conducted, required that a mediation conference be conducted. And it is our opinion, and we argue this below, that in doing that, the trial court was actually exceeding its jurisdiction. I don't believe that a lot of those orders were valid. That said, I understand what the judge was trying to do. He was trying to do equity. He wanted to give them an opportunity to mediate, meet with the bank, see if a settlement could be reached.
In fact, there was even a deposition in Iowa.
Correct.
The attorneys went up there, took the deposition, came back.
And Judge, I very strongly question again whether any of this should have been going on. But in a scenario like this, where there's a almost 5-year period between when a judgment is entered and then when the court ultimately says, I'm going to set the sale, to me that's the antithesis of I didn't receive due process. This court gave these appellants far more of an opportunity to flesh out their arguments, obtain evidence, do whatever they deemed appropriate relative to that sale than most litigants ever receive. And in this situation, when we have a final judgment that, as of today, still remains in full force and effect, and it contemplates that there's going to be a foreclosure sale of this property, and we ask the court to, in essence, simply enforce a final judgment that's been in effect for 5 years, that's not an abuse of discretion. That's not an arbitrary or fanciful or capricious act. That's just the court following a valid final judgment. And so, in our estimation, this is not a difficult appeal. I understand that the facts became convoluted because of the events that transpired when the bank sought the writ of possession. But when you look very carefully at what actually occurred here, they received the due process. The court probably exceeded its jurisdiction to give them some additional due process, but ultimately the court got it right. The court said, you're entitled to that foreclosure sale under the terms of that judgment. You're entitled to be reimbursed for the additional expenses that you've incurred as a result of being required to jump through these additional hoops. There is no basis for me ordering you to mediate a second time. Frankly, I shouldn't have probably ordered mediation in the first place post-judgment. And there's no basis for conducting any additional discovery here. The case is settled. There was a judgment entered. All that I can do at this point is enforce that judgment by having a foreclosure sale. And so it is our position, Your Honors, that the orders that were entered in January of 2014 were entirely reasonable, and they were certainly not an abuse of discretion, and therefore they should be affirmed. Thank you.
Okay, thank you.
Let me ask this question on the due process issue. The court had a hearing on July the 31st at which there was argument about the Stern issue. There was some argument about the affidavits. Subsequently, motion was filed. Defendants filed a supplemental memorandum in support of renewed motion for mediation, where the Stern issue is discussed, the affidavit issue is discussed, Rule 1.540 is discussed. What else would the defendants have said at the hearing in December that hadn't been said previously, and was there any proffer to the court of that made or attempted to be made?
To the second question, there was a proffer attempted to be made. And that's on page 11 of the transcript of December 19th, 2013. And I have preserved the objection. I stated to the court, I understand that we can oppose the motion at a hearing and raise our objections at a hearing in absence of a written motion or written objection. There were certain arguments made in the motion for mediation or the response to plaintiff's objection for mediation that were directed to mediation. But yes, the objection was preserved, that we didn't get to produce or introduce evidence or argument at the hearing. And as to the arguments that could have been made.
Before you, because I want you to see if you could respond to his question. I think Judge Solero's question was a proffer made? You indicated that you made an objection, but did you proffer? Did you say, Judge, let me bring in this witness, let me, let you hear this, and to proffer that for purposes of appeal? Has that been done?
Sure. I had stated to the court I had my clients with me, Yields and Karen Behon. They were prepared to testify as to the mediation issue. As to the question of standing or the affidavits, there's no specific objection as to that on the record. However, I would impress on the court, if you look at the transcript, things progressed quite quickly, and reading while the need to object exists, also reading the court and what was happening in the room, I believe I responded most appropriately under the circumstances.
With respect to the question of mediation, that is inherently a discretionary exercise, right? In other words, there is no law that compels a trial judge to grant a party's request for mediation. Is that correct?
I would agree, yes.
And if that's true, why wasn't the trial judge free to say, I just don't see that mediation is going to have any additional value.
I'm optimistic. I'm an optimist by nature, and I've had effective mediators help bring sides together when I thought there wasn't going to be an agreement. The homeowners want to stay in their home and reach a workout, and I think communication was an issue throughout this case. One thing I would point to the court out is the disposition of mediation conference that occurred August 27th, 2010, and the Bank of America's argument is that mediation occurred, and very clearly there's a note on the report of the mediator. Plaintiff's attorney advised she did not wish to mediate in the absence of defense counsel. Defense counsel was in Orlando, wanted to appear by phone because of his ill health. So it's quite clear to me from the record that no mediation went forward.
Well, did you file a motion to compel mediation?
Yes, we did a renewed motion for mediation, and that was ruled.
Motion. How about a motion to compel? It sounds like if mediation was ordered, they failed to comply with the order. So that begs the question, you moved to compel it. It doesn't appear that you did. But the question is, the judge allowed you to submit memorandums of law, and Judge Little did ask, I don't know if you were counsel below or not, but did ask you, do you have any new arguments not raised in your motion?
I believe that was
That was December 2013?
Okay, I'm not sure which part of the transcript the court's referring to. The court had requested written memorandum as to the mediation issue, so that was the one that was briefed, but there was no standing order in the lower court that everything had to be in writing. Often motion hearings go on where one side files a motion and there's no written response by the other side, but objections are made at the hearing. So that's often the practice in foreclosure cases in my experience. And to an earlier point, I would point out to the court as well, Judge Silver's order of January 4th, 2011, paragraph 1, on June 4th, 2010, this court entered an order granting plaintiff's motion to vacate the uniform final judgment, dismiss the action, and discharge the notice of lis pendens. So it's my understanding that the court understood that the final judgment was vacated.
But there's no such motion and no such order in the record, right? And your brief doesn't even contend that there was.
The motion was called, I think, motion to vacate sale. But I think what in effect the court, I don't know if the trial court exceeded its authority or not, if it can do its own motion under Rule 1.540B, but...
well, it references a June 5th order that just doesn't exist, or at least isn't a part of this record.
Correct. That should have, I think, read May 4th. I think it was a scrivener's error. Perhaps the hearing was May 4th. But yeah, I would stipulate that that's a scrivener's error in the order. I think there's many scrivener's error in this record, but the date aside, the court in its order of January 4th, 2011, states that the court entered an order granting plaintiff's motion to vacate the uniform final judgment. I think that's how the court proceeded with requiring plaintiff to prove up its standing and allowing us to take deposition.
That was relief, though, that nobody requested and that the May 4th order unambiguously did not grant, right?
Yes, that's accurate.
You've got just a couple more minutes left if you want to be able to wrap it up, sir.
Sure. As to the discovery issues, with the July 31st hearing where the court ordered depositions could be taken of the affiants that had filed affidavits to support the standing issue, plaintiff hadn't filed anything objecting to the discovery in itself, just that that depositions couldn't be taken. We had set a deposition for a few days before the hearing, and that never occurred. But a couple months after the hearing, after the depositions were taken, that's when plaintiff filed new arguments that there should be no post-judgment discovery, which wasn't raised prior to the depositions. So I don't agree that the court exceeded its jurisdiction in ordering some discovery post the final judgment. Finally, again, I brought forth to the court on December 19th, 2013, and it was myself at the hearing, that we wished to present argument, and the court simply denied that request. We were set for an hour. There was ample opportunity for the court to hear argument, and it chose not to. We weren't on notice that the court wasn't going to hear argument at the hearing, and I think that was a violation of due process. One final point, and I'm going to go back to the report of the referee, which was adopted by the Florida Supreme Court in its ruling against David J. Stern. The scope and magnitude of what happened with David J. Stern's office is really unprecedented in Florida. The Bank of America is relying on very technical arguments, which I think have merit in the right context. However, the wholesale fraud upon the courts of David J. Stern's office, which is, there's many factual findings in the report of the referee.
Well, we're aware of that parade of horribles.
Okay.
And I don't know if your clients are here or not, but they need to understand there's no specific evidence of fraud in this case. Just because fraud permeated from Mr. Stern's office doesn't mean that we adopt the theory that the public does of guilt by association.
Okay.
We need facts. We need evidence. And in this particular case, we don't see it. Maybe your clients need to understand that. I'm sure there was fraudulent conduct by that office. It's just not demonstrated in this case.
And to that point, Your Honor, we were prepared to make arguments to that effect at the hearing on December 19th, 2013, and the court didn't permit argument to be made. So I believe we lost our opportunity to do so. And again, the transcript reflects what happened at that hearing, and I believe our objection was preserved, and we were not on notice that we were not going to be permitted to have argument at that hearing.
All right. Thank you, sir.
Thank you.
All right. So